Professor Jameson here. This is going to be the lecture materials to accompany Chapter 2, Legal Reasoning and Analysis. This is a rather long chapter, and the concepts are difficult to master, particularly with people with no legal background. So we're going to be spending 2 weeks on this chapter, and hopefully by the end of the second week, you'll have a better understanding of these concepts. If not, we can talk about that individually. The chapter will cover stare decisis, judicial opinions, legal analysis of statutory law, which are what you think of as laws, and reasoning by analogy and deductive reasoning. Okay, I would invite you to pull up the PowerPoint that accompanies the lecture, because I'm just going to follow along by the PowerPoint. And so that would be a good idea. Or like I said in chapter 1's lecture, print out the PowerPoint and take notes as you go along. That would be another way to handle this material. Let's talk about stare decisis. It's a Latin term that means it's already been decided. So if something's already been decided, we don't have to relitigate or redecide the issue again, at least from the judge's point. Stare decisis is basically a legal concept that says when a court has set forth a legal principle in a previous case, that court and courts under it, kind of in the chain of command, I'll explain that later on this week and next week, have to follow that principle in future cases when the facts of the two cases are substantially the same. In this lecture, I will kind of follow along with the book. I'm on page 16 of the chapter 2 of the 5th edition of our textbook. And if you don't get it through this explanation, don't worry. There's going to be some exercises next week that might help you understand this concept a little bit better. So I'm going to present it this way first, and then in another way next week. Okay, so your book starts out with talking about the famous case of Griswold versus Connecticut. Okay, Griswold was a case that came out in the 1960s. The issue in the case was whether a state, in this case Connecticut, could ban the use of contraceptives, even between husband and wife. Okay, now today we would think that that would be crazy, that the state could actually prevent husbands and wives from using birth control such as condoms and the pill, things like that. But at this time, you know, it was kind of before the women's lib movement, and the country, even though this was the 60s, was still fairly conservative. And it was an issue to be decided by the court. Okay, and here was the problem in Griswold. There was nothing specifically in the Constitution. This was a case before the Supreme Court of the United States. And there was nothing specifically in the Constitution that said that this was really none of the government's business. So the Supreme Court, at least this is my take on it, looked at the case and said, this is ridiculous. There's no way that it's constitutional for a state to tell husband and wife, you know, how to regulate their birth control. But the problem was there was nothing in the Constitution that they could hang that decision on. So what they did is they looked at the Constitution as a whole and they said, hey, you know, there's nothing specifically, you know, in the Constitution about this. Obviously, you know, freedom of speech, freedom of religion, all that stuff is in there. But if we look at the Bill of Rights as a whole, we're going to interpret it as there's this penumbra. And a penumbra is like, when you look at a solar eclipse, the areas around the moon where the sun kind of sticks out and shines in a full eclipse, that's a penumbra. Okay, so they said there's this penumbra of protection in the Constitution itself. And this penumbra creates a right of privacy. And so now we're going to hold and we're going to rule that the Constitution has a right of privacy in it. Okay. We kind of take that as a fact today, but there's a very, very good legal argument that Griswold was incorrectly decided. Now, I agree with the result. I think most people would agree with the result. But the legal reasoning under which Griswold was decided was shaky. And what the Supreme Court did is they created an entirely new right to privacy that never existed and never was stated in the Constitution. Now, lots of states like California, in our state constitution, we have a right to privacy right in the Constitution, but it is not in the United States Constitution. So Griswold was criticized by a lot of legal scholars when it came out, but it was the Supreme Court's right as the ultimate authority on the Constitution to interpret it the way they saw fit. But the critics said this is going to open up a whole new can of worms. It's not going to just stop with Griswold. And you know what? They were right. Now let's use Griswold and apply it in a future case to see exactly how lawyers argue legal reasoning, okay, how we argue before the court. Okay, what we do is we look for cases that are similar to our case. And if we like the case, we say it's really similar. If we don't like the case, if it hurts our client, we say either the law is really bad or the law is not on point in this case, or the facts of our case are different. Okay, so when we like a case, we say how similar it is to our case or our client's case, and when we don't like a case, we point out the differences. And that's really all the key to legal reasoning is. Okay, so let's look at Griswold and what happened after Griswold was decided and became the law of the land. A case came up in the early 70s. I'm sure you're very familiar with it. It's called Roe versus Wade. Roe versus Wade, as you may know, had to do with abortion, and it involved a Texas law that outlawed abortion except in the circumstances to save the mother's life. Okay. Now, the lawyers on behalf of the plaintiff in the case, which was, we'll call her Mrs. Roe, that was not her real name. She has subsequently come out and identified who she was, but for purposes of privacy, the court will create a fictional plaintiff named Roe or Doe or whatever it might be. Okay, so Wade, if you want to know, he was the Attorney General of Texas in charge of enforcing law on behalf of the state of Texas. Okay, so what the plaintiffs said in Roe was, this case is similar to Griswold. Just like Griswold involved contraceptive, okay, a woman's right to choose in a way is like contraceptive. This case involves a right to privacy. And so you should follow your decision in Griswold, extend it to a woman's right to choose. And that's exactly what the court did. They took Griswold, they used it as the guiding case, and they extended the ruling in Griswold to allow a woman to terminate her pregnancy, but not unlimitedly. Okay, basically for the first 3 trimesters, and then there were restrictions in the second trimester, and then the third trimester, the court said you could go ahead and prohibit abortion altogether. The state of Texas in Roe obviously wanted to distinguish Griswold, but they also made an argument that the state had a compelling interest in protecting the life of an unborn child. Okay, the Supreme Court did not necessarily buy that right, and they went into a discussion about the viability of the fetus and things like that, and that's why we came up with the kind of 3 trimester rule that came out of Roe. First trimester, basically abortion on demand. Second semester, state could impose reasonable restrictions, and third semester they could go ahead and outlaw abortions. Okay, so that was Roe. Okay, one of your discussion points this week is about Griswold and Roe, and I don't want to have a big debate on the merits and morality of abortion. Okay, in my opinion, that's a personal decision, and I don't want our forum to blow up with a bunch of hating about whether you believe in the woman's right to choose or whether you believe a fetus is life upon conception. Okay, there are good arguments on both sides, in my opinion. The next case that came up in the abortion arena although there were other ones as well. The most important one, as far as our discussion, is Planned Parenthood versus Casey. Okay, this was a 1992 case, and this was a case where the state of Pennsylvania wanted to put some restrictions on abortions. Okay, and states are still doing this today. Okay, Texas just passed a law making it virtually impossible for women in rural areas to get abortions, and that case definitely is going to make its way up to the Supreme Court sometime in the next few years. So this debate is still ongoing. Okay. Now, the issues in Casey were the state of Pennsylvania passed a law that, one, required a 24-hour waiting period for an abortion after you go in for a consultation. They argued that there was an interest in, making hasty decisions, giving a woman time to think about it. And the other thing that they put in the law was that you had to get your husband's consent for the abortion if you were married. Okay, so now we've got Griswold, now we've got Roe, and now we've got a decision before the court to be made in Casey to determine whether Pennsylvania's restrictions are constitutional, whether they're going to inhibit a woman's right to privacy and her right to choose. The plaintiffs in the case argued that these restrictions essentially restricted a woman's right to abortion. For example, if she couldn't get her husband's consent, she could not have an abortion. If she had to wait 24 hours, people in rural areas, they'd basically have to stay overnight, and they might not be able to afford it, and things like that. Okay, the state went ahead and tried to distinguish Roe from Casey, saying basically that these restrictions weren't all that significant. Okay, so the plaintiff is relying on Griswold and its progeny Roe. The state is trying to distinguish Roe from Casey, saying that it's within the constitutional limits of the prior decision of Roe. Now, in Casey, the court went ahead and upheld the 24-hour requirement, saying that that was reasonable. They struck down the part of the law that required parental consent, because obviously if your husband said no, you effectively be giving them the decision instead of the wives. And this is certainly the woman's decision, although maybe it should be made as a couple together. Ultimately, it's the wife's prerogative in that regard. Okay, an interesting side note to Roe, and I'm going to get to Casey, and I'm going to tell you about this just so you have a little bit of an idea of how the Supreme Court decides cases and how close we were to basically overturning Roe. Okay, when the original case was voted on by the Supreme Court, the original vote was 5-4 in favor of the state of Pennsylvania. The court was ready to strike down Roe versus Wade and allow states to choose whether they wanted to allow abortions or not. Again, immediately after the case was voted on in the preliminary vote, Justice Scalia went back to his chambers and he began writing the decision to overturn Roe versus Wade. In the meantime, Justice Blackmun, who was the justice who actually wrote Roe versus Wade, went to Justices O'Connor. That's why we have Justice O'Connor on the top of the page for this week, one of the great American justices of all time, in my opinion, and Anthony Kennedy, who was one of my former law professors. He went to them and he said, listen, if we go back on our decision in Roe, it's been standing for 20 years. People are going to start questioning our decisions in other cases. And if it's one thing I learned from Anthony Kennedy is the thing the Supreme Court is most concerned about is their legitimacy. They're 9 unelected officials who are appointed for life. And they're very concerned that when they issue a decision that the public accepts it. Okay, they don't want to go back to Brown versus Board when we desegregated the schools and have the whole country not necessarily have faith in their decisions. So Justice Blackmun went to Justice O'Connor and Justice Kennedy In a sense, they got cold feet and they changed their mind. And they decided to uphold Roe. But in return, they got some concessions from the other three liberal justices on the court that limited abortion in the Casey case, but not overruling Roe all the way.